In 1927, a young woman sat in a courtroom in Virginia while two lawyers argued about whether the government had the right to make sure she could never have children. She was 18 years old. She had already given birth once to a daughter she would never raise. The pregnancy had come from a rape. The rape had been committed by a nephew of the family she had been placed with as a ward. When she became pregnant, the family had her committed to a state institution for the feeble-minded. Her name was Carrie Buck, and her case was about to become the legal foundation for one of the largest government sterilization programs in the history of the modern world. The lawyer assigned to defend her was a eugenics advocate who deliberately lost the case. By the time it reached the Supreme Court of the United States, Carrie Buck had become a legal abstraction, a test case dressed up as a person. The court ruled 8-1 that the state had the right to sterilize her. Justice Oliver Wendell Holmes, one of the most celebrated legal minds in American history, wrote the majority opinion. His conclusion, in the official record of the United States Supreme Court, reads, "3 generations of imbeciles are enough." That ruling was handed down in 1927, and I need you to hold a date in your mind as this story unfolds, because we are not talking about something that ended there. The last known forced sterilization carried out under these laws happened in 1981. Stay with me on that. Before we get to what that number means, and it is going to mean something different by the end of this than it does right now, you need to understand what existed before Carrie Buck ever sat in that courtroom. Because the program that consumed her was not improvised. It had been decades in the making, and it had the full institutional support of the American medical establishment, the American legal system, and the federal government. The eugenics movement in the United States did not begin in the shadows. It began in universities. In 1904, the Carnegie Institution funded the Station for Experimental Evolution at Cold Spring Harbor, New York. Charles Davenport, a Harvard-trained biologist, ran it. He built the Eugenics Record Office, which cataloged the hereditary traits of American families and lobbied state legislatures to pass sterilization laws. His funders included the Harriman Railroad fortune and the Rockefeller Foundation. This was not fringe science. This was establishment science, backed by establishment money, pursued through establishment channels. Indiana passed the first compulsory sterilization law in 1907. By the time the Supreme Court ruled in 1927, 15 states already had similar statutes on their books. After Buck versus Bell, the number grew to 30, and the targets were never random. The eugenics movement had a very specific idea of who was unfit to reproduce, and that idea mapped almost perfectly onto who already had the least power in American society. Black women in the South were sterilized at rates so disproportionate that civil rights activists gave the practice its own name. They called it the Mississippi appendectomy, referring to hysterectomies performed without consent on black women in teaching hospitals. Procedures used as surgical training exercises on patients who were never told what was being done to them. Fannie Lou Hamer, one of the most important figures in the entire American civil rights movement, was sterilized without her consent during a routine surgery in 1961. She found out afterward. She spent the rest of her life talking about it. Native American women were targeted through Indian Health Service facilities. In 1976, a Government Accountability Office investigation, the government's own investigators, found that at least 3,406 Native women had been sterilized between 1973 and 1976 alone. 3 years. 3,406 women. Many had been presented with consent forms in English they could not read. Others were told they would lose their welfare benefits if they refused. Some were approached for consent while they were in labor. And in Appalachia, poor white women were institutionalized under classifications of feeble-mindedness that required no clinical evidence, no independent medical review, no due process in any meaningful sense. A county official, a social worker, or a family member with enough credibility could initiate the process. Once inside the system, there was almost no way out. Now, here is where someone watching this might push back, and I think it is important to sit with the counter-argument honestly. The eugenicists were not all cynical men who knew they were doing evil. Many of them genuinely believed they were practicing progressive science. The word eugenics was coined by Francis Galton, a cousin of Charles Darwin, and in the early 20th century, it was embraced by figures across the political spectrum. Progressives who believed in scientific management of social problems, conservatives who feared immigration, academics who thought they were applying Darwinian logic to human welfare. Theodore Roosevelt wrote about it. Woodrow Wilson signed New Jersey's sterilization law. The movement had mainstream intellectual credibility in a way that is genuinely uncomfortable to reckon with. But here is the problem with the good intentions defense. It breaks on the evidence. Carrie Buck was not feeble-minded. Decades after her sterilization, researchers traced her life and established that she had lived a completely normal existence. She read newspapers, wrote letters, was remembered by neighbors as sharp and engaged. Her daughter, Vivian, the third generation of imbeciles in Holmes's famous phrase, made the honor roll at her elementary school before dying of a childhood illness at age 8. The entire scientific premise of the case, that feeble-mindedness was a hereditary trait that could be identified and eliminated, was not science. It was classification in the service of a conclusion that had already been reached. And then there is the detail that should end the good intentions argument permanently. In the 1930s, German eugenicists were developing the racial hygiene laws that would become the legal architecture of the Holocaust. They studied American sterilization programs explicitly. They cited Buck versus Bell in their own legal texts. They corresponded with Charles Davenport at Cold Spring Harbor and called the American program a model. At the Nuremberg doctors' trial after World War II, Nazi defendants quoted U.S. eugenics statutes in their own defense. They were not wrong that the inspiration had come from somewhere. The American program predated the Nazi one by nearly 30 years. But if you thought the story ended with the moral reckoning of Nuremberg, stay with me, because this is the part that most accounts leave out entirely. The laws did not come down after the war. States did not repeal their eugenics statutes in 1945 out of horror at what those same ideas had produced in Germany. North Carolina's Eugenics Board kept operating until 1977. Virginia did not repeal its sterilization law until 1974. And Oregon, the last state to formally close out its eugenics program, documented a forced sterilization in 1981. 1981. The IBM personal computer launched that year. MTV launched that year. And somewhere in Oregon, under a law that traced its legal authority directly back to Buck versus Bell, a person was sterilized by the state without their meaningful consent. That number, 1981, is not a footnote. It is the answer to a question nobody asked loudly enough. The question being, when did this actually stop? The answer, officially, is that it stopped at different times in different places, under different laws, and that in some documented cases involving incarcerated women and immigrant detention facilities, the practice continued well into the 21st century. A 2020 whistleblower complaint from a nurse at an ICE detention facility in Georgia alleged that a gynecologist was performing hysterectomies on detained immigrant women at an extraordinary rate, with inadequate informed consent. The Department of Homeland Security's own Inspector General investigated. The doctor lost his medical license in 2022. The through line from 1907 to 2022 is not a coincidence of isolated incidents. It is a consistent institutional logic that resurfaces whenever the same conditions are present. A population with limited legal recourse. A medical establishment with the authority to define normalcy. And a government with a stated interest in who gets to reproduce. Here is what the reckoning looked like when it finally came. North Carolina established a compensation fund in 2013 for living victims of its eugenics program. The payment was $20,000 per person. By the time the fund opened, most of the people who had been sterilized were already dead. The ones who were still alive were elderly, many of them in poor health, many of them still processing something that had happened to them as teenagers or young adults. $20,000 offered 80 years later after a lifetime of living with what had been taken. California issued a formal apology in 2021. Virginia erected a historical marker near the site of Carrie Buck's sterilization. Buck versus Bell, the Supreme Court case that made all of it legal, has never been overturned. It sits in the United States reports as valid constitutional precedent. No subsequent court has struck it down. Any state that wanted to pass a new compulsory sterilization law today would find, upon searching the case law, that the Supreme Court already ruled on this question, and that the government won. Carrie Buck lived until 1983. She outlasted the eugenics board that had sterilized her by 6 years. She had spent her adult life in and out of institutions, then eventually settled in a small house in rural Virginia with her husband. She tended a garden. She collected welfare. Late in her life, researchers found her and asked her about what had happened. She said she thought the whole thing had been a great injustice. She said she had always wanted more children. She died 2 years after the last forced sterilization under eugenics law in American history. She never received an apology. She never received compensation. The legal decision that had been built on her body remained, and remains, the law of the land. There is a particular kind of historical crime that is easy to recognize in retrospect and almost invisible in the present. It requires legitimate institutions, courts, hospitals, universities, legislatures, operating within their normal authority, using the accepted scientific and legal language of their era, pursuing goals that substantial portions of the population considered reasonable or even virtuous. It produces records, it keeps files, it publishes papers, it holds conferences. And then, decades later, when the moral consensus shifts, those records become evidence of something that everyone agrees was monstrous. And yet, somehow, the legal infrastructure built to enable it remains quietly in place, never formally dismantled, waiting for the next time someone decides the conditions are right. The eugenics program in America was not a secret operation. It was a bureaucracy. 60,000 documented victims is the number we can verify from records that survived. The actual number is almost certainly higher, because the records from the period when consent was not even pretended, when black women in southern hospitals were sterilized during unrelated surgeries without ever being asked. Those records were not kept the same way. You cannot count what was never written down. What was written down is enough. The Carnegie Institution funded it. The Supreme Court blessed it. 30 states legislated it. The medical establishment administered it. And for the people it was done to, the Carrie Bucks, the Fannie Lou Hamers, the thousands of Native women approached for consent while they were in labor, the loss was not abstract. It was the specific and permanent removal of something that could not be given back. And the law that made it possible is still there, untouched, in the books. That is not ancient history. That is an open door.